we're going to go ahead and get started. Kind of on a time crunch here today. After this presentation, we're headed down to Palmyra to do another presentation down there. Hopefully it's big. This is great. I've been doing this job for about 2 years, and this is the largest amount of people that we've ever had at a presentation. So thank you all for coming out here today. My name is Jay Turner. I'm the Director of Sunshine Law Compliance at the Attorney General's Office. I'm actually on my way out of this position. I'm moving into another position in the administration in our office, and my position will be taken over by Brandon Roberts here as in the director position. A little background on myself. I am originally from Southern California. Please don't hold that against me. I grew up in San Diego. Both of my parents are retired highway patrol officers, and I spent most of my career as a state parole agent and a securities fraud investigator before moving to Missouri in 2015. Came to work at the AG's office working on both civil and criminal cases. In 2017, I was promoted to our public safety manager position, and the Attorney General's office is a public governmental body, so we have sunshine law responsibilities. And part of my responsibilities in that role is when someone would make a request for public records for criminal investigations, criminal prosecutions. Part of my job was reviewing those requests, determining what was open, what was closed, determining what was responsive, what wasn't, and kind of coordinating all that. So I've had about 6 or 7 years of hands-on experience with the Missouri Sunshine Law, with law enforcement records specifically. And then in February of 2023, I was promoted to this role. And in my job in this position, in addition to traveling the state and giving these types of presentations, our unit is also the one that investigates alleged violations of the Sunshine Law by public governmental bodies in Missouri. So throughout this presentation, I'll refer to a public governmental body as a PGB. We give quite a few of these presentations. My voice is already starting to go out, and I still have another presentation later on this afternoon. So if I say PGB, I'm referring to a public governmental body. Little disclaimer here, nothing that we're talking about here today is meant to be legal advice either by myself or by the Attorney General's office. Full disclosure, I am not an attorney. Brandon is not an attorney. Our role is more of an investigator role. The Missouri Revised Statutes talks about who the Attorney General's office can provide legal advice to. And by law, our office can only provide legal advice to state agencies, so the Department of Corrections, the Department of Mental Health, the Department of Health and Senior Services. We can't provide legal advice either to local public governmental bodies or to private citizens. And I like to make that disclaimer when we start a presentation, because a lot of times we'll get phone calls from local PGBs, from private citizens saying, hey, is this record open or closed? Can they close this meeting? For those types of definitive answers, we can't give you a definitive yes or no. That needs to come from the legal counsel for the public governmental body that makes that determination. We can point you to relevant statutes that might be able to assist you. We can give you what our best practice evaluation might be, but we can't tell you yes or no definitively. That needs to come from the public body. There's a quote that I came across that I think sums up what the Sunshine Law stands for. Democracy's got behind closed doors. When government begins closing doors, it selectively controls information rightfully belonging to the people. Selective information is misinformation. I'm sure everyone here has heard of FOIA, or the Freedom of Information Act. FOIA is actually a federal law that applies to federal government agencies. It does not apply to the state of Missouri. So when you make a Sunshine Law request to a public body, even if you incorrectly reference FOIA, if the public body can interpret that as a public records request, they need to treat it as a public records request. We've had situations where public bodies have said, well, they made this records request pursuant to FOIA. FOIA doesn't apply to us, so we didn't respond. That's not something that a public governmental body can do. If they can interpret something as a public records request, regardless of what law you invoke to get those records, they do have to treat it as a public records request. So what exactly is the Sunshine Law? So the Sunshine Law is the public policy of the state of Missouri that all meetings, records, votes, actions, and deliberations of PGBs are open to the public unless otherwise provided by law. The Sunshine Law shall be liberally construed and its exceptions strictly construed to promote this public policy. So basically what this means is all meetings, records, votes, actions, and deliberations of PGBs are presumed to be open. They are open by default. If a public governmental body is going to close meetings, records, etc., they need a legal reason to do so, and they have to provide that legal reason to you in their response to it. The takeaway from that is public business is the public's business. And you'll notice in the lower right-hand corner, we have a legal citation and a page number. What we're talking about on the screen is where you can find that in the law, and the page is where you can find it in we have a physical Sunshine Law booklet, and that same booklet is also available in electronic form on our website. They're both the exact same booklet. Just some people prefer a physical booklet, some people prefer the online booklet. I personally prefer the online booklet because if I'm investigating a complaint, I can use Control F and I can find keywords in that online document that you obviously can't find in that physical document. I actually meant to bring our booklets here with me today, but they're being reprinted. Last session, there were some minor changes to the Sunshine Law, so we're updating those booklets, and we'll make those available once they are reprinted. So who does the Sunshine Law apply to? So it applies to Missouri public governmental bodies. That includes municipalities such as cities and villages, that includes counties, state agencies, police departments, special districts, and committees. There was a study done a few years ago by the website governing.com that looked at public governmental bodies across the United States in relation to population. And the state of Missouri has almost as many public governmental bodies as the state of New York, and they have 3 times our population. A big reason for that is Missouri has a lot of special districts. We have ambulance districts, we have fire districts, library districts, taxing districts, sewer districts, water districts. I think last count there was close to 5,500 special districts in Missouri alone. Sunshine Law also applies to committees. So say a city council or a county commission decides to appoint a budget committee to study the budget. Because that budget committee was created by and responsible to that parent governmental body, that city council or that county commission, that committee, that budget committee, has Sunshine Law responsibilities just as that parent public governmental body does. And we'll talk about those specific requirements later in our presentation. So what is a public governmental body? So the Sunshine Law defines a PGB as any legislative, administrative, or governmental entity that is created by the Constitution or the statutes of this state, that's the RSMO, the revised statutes of Missouri, or by order or ordinance of any political subdivision or district. So last part of this sentence, by order or ordinance of any political subdivision or district, is basically what gives a public governmental body the power to create another public governmental body. And when they create a budget committee or some other kind of subcommittee, that's essentially what they are doing. They are creating another public governmental body with Sunshine Law responsibilities. So I talked a little bit about a committee of a public governmental body, but what about a subcommittee or an advisory committee? So say that budget committee decides, well, we need to appoint a special committee to study salaries, or the Parks and Rec budget, or the health department's budget. So now you have that parent governmental body, that city council or that county commission, that budget committee, and then you have a salary subcommittee or a Parks and Rec subcommittee. That subcommittee, because it was created by and responsible to a public governmental body, is in itself a public governmental body with Sunshine Law responsibilities. The same would generally also hold true if a public governmental body created, say, an advisory committee. So say a city or a county wants to create an advisory committee of private citizens, not even elected officials or public officials, to study a specific issue. Say they want to build a new police department or a new health department. So they appoint an advisory committee of private citizens to study that issue and then report back to the parent public governmental body. That advisory committee, because it was created by and responsible to a public governmental body, is in itself a public governmental body. We've had complaints where a public body has said, well, we appointed an advisory committee, but because it's comprised of private citizens and not public officials or elected officials, it's not a public governmental body and not subject to the Sunshine Law. And that is generally not correct. What matters is who created it and who it's responsible to that define whether or not it falls within the confines of a public governmental body. So who is not covered by the Sunshine Law? So I don't know what our numbers are for 2024, but I know for 2023 we had about 600 Sunshine Law complaints across Missouri for Sunshine Law complaints. Some of those complaints fall outside the scope of the Sunshine Law. And some of those examples would be private entities, Subway, Target, Walmart, private organizations, private businesses. They're not public governmental bodies, not subject to the Sunshine Law. And yes, we actually do get Sunshine Law complaints against Walmart. Homeowners associations and property owner associations. I think there's a misconception that because those organizations have boards, they hold meetings, they take minutes, they post notices, that they must be a public governmental body, and that's not the case. Those are private organizations not subject to the Sunshine Law. Non-Missouri governmental bodies, so this would be federal agencies or agencies based in another state. Missouri Sunshine Law only has jurisdiction over Missouri public governmental bodies. Judicial entities when not operating in an administrative capacity. So the courts have Sunshine Law responsibilities when they're operating administratively, their budgets, administration, things like that. That's where the Sunshine Law would have jurisdiction. But if the complaint or the records request has to deal with judicial records, or the court's operating in a judicial capacity, documents from a court case, things off of CaseNet, generally speaking, the Sunshine Law does not have jurisdiction over those types of situations because they're operating judicially and not administrative. This would also apply to a local public governmental body's municipal court. I think a lot of the reason that has to do with the separation of powers doctrine. We have 3 equal branches of government where there's some autonomy in each. The Missouri courts actually have their own rule that deal with court records, requests for court records, and complaints about public records within the courts operating judicially, and that's Missouri Supreme Court Rule 2. So if we get a complaint or a request that deals with court records or items off of CaseNet, we don't have jurisdiction to look into those types of complaints. We need to refer those back to the courts to be viewed through the lens of Missouri Supreme Court Rule 2 rather than the Missouri Sunshine. Nonprofit corporations. So a vast majority of nonprofit corporations are not subject to the Sunshine Law. Those are, again, 501c3s, 501c4s, private organizations. There is a very narrow area of the Sunshine Law where an entity could be considered what's called a quasi-public governmental body. And quasi meaning part. Prior to 2023, there were 2 or 3 benchmarks that an entity had to meet in order to be considered a quasi-PGB. And that was the first benchmark. It has to be organized under specific chapters of Missouri law. And I believe it was 352, 353, and 355. If it met that benchmark, then it had to meet the second benchmark, where that organization's primary purpose, it couldn't be an ancillary purpose or a subsidiary purpose, but its primary purpose and its articles of incorporation filed with the Secretary of State's office had to be to enter into contracts with a public governmental body. In 2023, there was a gentleman by the name of Mr. Malin who made a request to an organization known as the Missouri Association of Task Forces. And he requested records from this organization. That organization replied back and said, well, we don't have to give you this information. We're not a PGB, we're not a quasi-PGB. Mr. Malin disagreed and he filed a lawsuit. And when the court looked at that particular entity, that not only identified those benchmarks that I mentioned previously, but the court also identified other benchmarks that an entity had to meet in order to be considered a quasi-PGB. So rather than having those first 2 or 3, I think there are now 7 benchmarks that an entity had to meet. So I think now a lot of entities that could have been considered a quasi-PGB are likely no longer considered a quasi-PGB. If you're interested in that court case, if you're a court case nerd like I am, Malin, M-A-L-I-N, versus the Missouri Association of Task Forces is the name of that case. Mr. Malin actually disagreed with the circuit court case. He appealed to the appellate court, and the appellate court actually upheld the lower court's decision. So that court case, it now stands as law in Missouri. Most individual employees or board members. So the Sunshine Law applies to records that are retained by or of a public governmental body. They don't apply to personal records or personal effects. I put this bullet point in here. We had a complaint filed by somebody who wanted to know what the salary of a presiding commissioner was. But instead of putting his Sunshine Law request to the custodian of records of that county where that presiding commissioner served, he sent his request to the commissioner directly and wanted the commissioner's personal bank records. Personal bank records obviously are not subject to the Sunshine Law because they're not retained by the public body. So we were able to refer that gentleman back to that county custodian of records to have his records request viewed through from the county. An interesting point about that, and we'll talk a little bit further in the presentation about chapter 610.021 of the Sunshine Law. And I mentioned earlier that all records, meetings, etc. are open by default, and a body has to have a legal reason to close them. A vast majority of those exceptions are contained in 610.021 about why a body can close meetings and records. One of those subsections is subsection 13. And that covers the personnel records of a public governmental body. So if somebody made a public records request for personnel records of a public employee, the body could potentially close the personnel records of that employee. However, under that subsection, there are 4 things that a body cannot close under the Sunshine Law. And that is the name, title, length of service, and salary of members of a public governmental body. So those 4 things a public body cannot close. So that member of the public had simply reached out to the custodian of records for the county and requested the presiding commissioner's salary. That salary is something the body could not close under the Sunshine Law. Section 610.028 is a section of the Sunshine Law that requires every PGB in Missouri to have a policy in place that is open to inspection regarding the release of information on any meeting, record, or vote. So if you're a PGB in Missouri, you must by law have a Sunshine Law policy, and you must have a custodian of records name that is available to the public upon request. That Sunshine Law policy can be as detailed as public bodies want it to be. Our office recommends that you be as detailed as possible, such as including things like when your meetings are held. If your meetings are held on particular dates at particular times, include that in your policy. Procedures about searching and producing records. Everybody is different about what their procedures are, about how they go about looking and copying records. So include that in your policy. How your fees are calculated. The Sunshine Law is specific about certain fees that a public body can charge. It's up to 10 cents per page, or the lowest hourly rate for employees of that organization as far as the research is concerned. But how those fees are calculated might vary between public bodies. So it's helpful to be able to include that information in your policy. And by the way, feel free to take pictures of any slides. After this presentation, I'm going to email a copy to Echo, and she can distribute it to anybody who wants a copy of it. It's a public record, you guys can have it. So feel free to take pictures, but also make it available after the presentation as well. Include details about who your Sunshine Law policy applies to. This is helpful because a lot of times larger jurisdictions such as Kansas City or St. Louis or St. Joe or Springfield might have multiple Sunshine Law policies depending on the body. They may have one for the city clerk, one for the health department, one for the police department. And other entities, smaller jurisdictions, a city might have one Sunshine Law policy that applies to all organizations within the city. So it's helpful to include in your policy who it applies to. So that way, if you're a member of the public reaching out to get records from your police department, and you find out, well, the police department has its own Sunshine Law policy, you're not wasting your time submitting your request to the city clerk for copies of those records. If you don't already have a Sunshine Law policy, we actually have a sample one on our website. It's in the form of a resolution that a public body can take that policy, adopt it to their particular PGB. We also have a records request form. It's a very generic form that members of the public can use to request records from any PGB in Missouri. We've actually had public bodies that have taken that request form and adopted it for their specific PGB and made it available to the public on their website or in their office or whatnot. And your public bodies are welcome to do that as well. All right, let's jump into public meetings. The Sunshine Law defines a public meeting as any meeting of a quorum of a PGB that is subject to the Sunshine Law, in which public business is discussed, decided, or public policy formulated. Those meetings can take place in person, they can take place electronically via email or text, they can take place via conference call, or they can take place via an online chat or message board such as Zoom or WebEx. And it can also be Zoom, Microsoft Teams, things like that.
When you have a board member that can't make it to a meeting but wants to be on phone call, does it have to be FaceTime or can it be just a call?
So it's going to depend on a couple of things. One, it's going to depend how that meeting is noticed. If it's noticed as an in-person meeting, but you happen to have maybe one board member or two board members that want to attend remotely, as long as a majority of your quorum is attending the in-person meeting, then you're generally fine. But when you get into a situation where you've noticed an in-person meeting, but then a majority of your board or all of your board is now choosing to attend remotely, that's when you kind of delve into, well, this should actually be a remote meeting instead of an in-person meeting at that point. But if it's just one or two people and it's not your quorum, it's generally not a big deal. The term shall also include a public vote of all majority of members of a public governmental electronic communication or other means conducted in lieu of holding an in-person meeting. So I put this bullet point in here because I was training a public body in the southeast part of the state that I'm not going to name. But they had told me, well, sometimes our practice is we're having our meeting, we're discussing things, and we realize we don't have all the information that we need. So we'll adjourn our meeting, the clerk will go up, gather the additional information, email it to us individually, we'll review it individually, and then we will email our vote to the clerk. And I said, it's likely that a court would interpret that as a violation of the Sunshine Law. Because while you're giving members of the public the opportunity to participate in the discussion, you're not giving them the opportunity to participate in the vote. So in that situation, you would want to post notice of another meeting 24 hours in advance with a tentative agenda to give members of the public the opportunity to come back and participate or witness that vote in a in-person setting. So real quick, I wanted to cover here when it comes to a public meeting that the two things that constitute a public meeting is your quorum is present and you're discussing, deciding, or formulating public business or public policy. Those two things have to be present generally for a meeting to be considered a public meeting under the Sunshine Law. And we'll discuss a little bit of how that differentiates in our next slide of what is not a public meeting. So a public meeting does not include an informal gathering of members of a PGB for ministerial or social purposes when there is no intent to avoid the purposes of this chapter. So this comes out of this court case here, Colombo v. Buford, where a body had gotten together for a social event. I don't remember exactly, but I think it might have been a Christmas party. And at this Christmas party, a majority of their quorum happened to be together because they were there at this Christmas party. And during this party, a spontaneous discussion came up about employee morale. What can we do to improve the morale of employees within our organization? And they were throwing ideas back and forth. Members of the public joined in on the discussion. And later on, there was a lawsuit filed that said, well, this was a public meeting. There was no 24-hour notice. There was no tentative agenda. And when the court looked at that particular gathering, they noted that all 5 of these bullet points were not present. There was a totally unstructured event with no agenda. Nothing was gaveled into order. People didn't take turns talking to the entire group. There were no trappings of what could be considered an official public meeting. But the court was very careful to note that if any one of these 5 bullet points had not been present, or if that body had gotten together for a social event under the guise of a social event, but really intended to conduct public business surreptitiously, it could have been held to be a public meeting under the Sunshine Law. So when I mentioned before that the 2 elements that need to be present for it to be considered a public meeting is a quorum present and you're discussing public business, if a body is intentionally not meeting as a quorum but discussing public business, maybe technically that's not considered a public meeting, but because they're doing it to avoid the Sunshine Law, a court may find that it is in fact a public meeting. So there is a misconception that just because a quorum of officials gets together for anything, regardless of what it is, that constitutes a meeting, and that's not the case. The 2 things that constitute a meeting is a quorum and public business is discussed. So if you're a public official and you happen to get together with your quorum and it's not a public meeting, hasn't been noticed, there's no tentative agenda, avoid discussing any type of public business. Because while you might not intend to violate the Sunshine Law, you don't want it to be seen by members of the public. So try discussing any type of public business if you happen to be in a social event or something along those lines. So types of public meetings. So back in my home state of California, we refer to closed meetings as executive session. Some bodies will refer to them as, they'll have special sessions, they'll have work sessions, and that's totally fine if a public body wants to have sessions with those special designations. But make sure to preface each one of those special designations by whether it's an open meeting or a closed meeting. So it's an open special session. It's a closed work session. And the reason for that is those are the only 2 types of meetings that the Sunshine Law defines. So it's easier for a public body to know what they can and can't discuss depending on whether it's an open or closed meeting. It's easier for you as members of the public to know whether it's an open or closed meeting and whether or not you can attend. And if our office is investigating a complaint, and we can easily tell what type of meeting that is because different rules apply whether it's an open meeting or a closed meeting. Last year I was investigating a complaint from a public body and I had to go back and pull 20 years worth of their notices and tentative agendas, and not one single time did they ever mention an open meeting or a closed meeting. They were using closed or special session, work session, executive session interchangeably. So it was just an absolute nightmare, and not the excuse, but the reasoning the clerk gave me as well, I've only been in this job for 5 years, that's how I was taught, that's how this person was taught before her. So just because a body has been doing something a certain way for a certain amount of time, doesn't mean it's the correct way. So that's why we do these trainings, to kind of get the word out on that kind of stuff. So if you have a public meeting, a body must post notice of that public meeting. It has to include the time, the date, the place or location, and a tentative agenda. The tentative agenda has to be, according to the statute, reasonably calculated to advise members of the public of the matters to be considered. So if a body even reasonably suspects that something's going to come up in a meeting that they're going to be discussing, our best practice advice is that you put that on your agenda. If you end up not discussing it and it's on your agenda, there's really no harm, no foul. But the danger comes in when something's not on your tentative agenda and you start discussing it in depth in a public meeting. And if that meeting is being conducted by telephone or other electronic means, include a location that the public can either observe or attend that meeting. So if it's a conference call, a call-in number. If it's a Zoom, a WebEx, a Microsoft Teams, a link for people to be able to view that. So if it's an in-person meeting, these 4 bullet points are required: time, date, place, and tentative agenda. But if it's a conference call, or if it's a Zoom meeting or an electronic meeting, then all 5 of these are required. That notice that we just talked about must be posted at least 24 hours in advance of all public meetings, both open and closed. It must be posted in a prominent place that's easily accessible to the public. And weekends and holidays don't count towards that 24-hour period. So say a body is holding a meeting on Tuesday at 5 p.m., but the Monday before was a holiday. That body would need to post notice of that meeting no later than 5 p.m. on that preceding Friday in order to be in compliance with the statute. Now, jump down real quick to our location requirements. The meeting has to be held in a place that is reasonably accessible to the public. That includes Americans with Disabilities Act requirements. And it has to be in a place that is sufficient size to accommodate the anticipated attendance. So if you have something on your agenda that you reasonably anticipate is going to be a hot button issue, or it's going to draw on a lot of people, try to make arrangements to hold that at a larger location to accommodate that attendance. If you don't end up needing that space, again, there's no harm, no foul. But the danger comes in when a public body knew something was going to be hot button and was going to draw on a lot of people, and they don't make those arrangements beforehand, and then you have a situation where there's not enough room for people to come into that meeting. That's when you fall into that kind of danger. So the things I just talked about: posting 24 hours in advance, a place that's reasonably accessible to the public, and a place that is of sufficient size to accommodate the anticipated attendance. The Sunshine Law refers to these as the normal requirements of the Sunshine Law. But there may be a situation that pops up where a body has to have a meeting that fall outside the normal requirements. So they have to have a meeting on less than 24 hours. They want to add something to the agenda on less than 24 hours. They have to hold their meeting at a place that's not reasonably accessible to the public. The place is not of sufficient size to accommodate the anticipated attendance. If one of these things occur, then these fall outside the normal requirements. And so a public body has a responsibility to do things under the emergency or short notice exception. So if one of these things happen that fall outside the normal requirements, they still need to post notice of that meeting as soon as practical, and they have to state the reason for the deviation outside the normal requirements in the minutes. So you had to have your meeting on less than 24 hours. Why? You have to state in your minutes. You had to have your meeting in a place that was not of sufficient size. Why? You have to state it in the minutes. If you do have to have a meeting, if a body does have to have a meeting that falls within that 24-hour period, a good rule of thumb is to look at the issue. Can this issue wait 24 hours in order to be in compliance with the statute? If it can, the best practice is then to postpone that meeting so you're within that outside that 24 hours and you're in compliance with the statute. But if you can't, nope, we can't wait, this needs to be discussed right away. You need to state in the minutes why that meeting needed to take place or that issue needed to be discussed when it wasn't on the tentative agenda beforehand. Some of the examples I give about potential things that could fall into that emergency or short notice justification: say there was a flood at City Hall and you had public records in danger of being damaged and you need to make a decision on where to move those records to. Or if that flooded City Hall, you couldn't have your normal meeting, you needed to move it to a community center or the county commission headquarters or something along those lines. Again, the reason why needs to be stated in the minutes. If you had a grant deadline that was getting ready, where the grant deadline was getting ready to expire, and you needed to make a decision on where to move those funds to, or else you were going to lose those funds, your community was going to lose those funds. That's another reason that could possibly be an emergency or short notice exception. One example came up last year, back in January, when we had all those storms, when we had trees down covering roads. There's a jurisdiction in the southern part of the state that was very small, and their public works folks can't make any decisions after hours or on weekends without the approval of their board of trustees. Well, when you have trees covering roads and highways, that becomes a public safety concern. So this entity needed to get together for an emergency meeting to authorize their public works folks to be able to clear those roads. They still posted, I think it was 9 hours before that meeting, and they stated in the minutes why that emergency meeting was necessary, because it was a public safety exception. So I mentioned that your tentative agenda has to be reasonably calculated to advise members of the public of the matter to be considered. And unfortunately, in the 51 years, the Sunshine Law was originally passed in '73, in the 51 years since the Sunshine Law was passed, there haven't been any court cases that have further defined how much more detail has to be in a tentative agenda. Right now, all it is the statute, reasonably calculated to advise members of the public of the matters to be considered. So we have here on our left side a potentially insufficient agenda versus our right side, which is likely sufficient. And we use words like potentially and likely because, contrary to popular belief, our office doesn't have the authority to say, yes, this was a Sunshine Law violation. The only entity that has that authority is a court of law. We can make recommendations, we can say this is a potential violation or a likely violation, but we can't say definitively, yes, this was, or no, this wasn't. That has to come from a court of law. So on our left side here, we have our unfinished business, we have budgets and park permits. Two things that seem pretty innocuous, it's probably not going to draw on a lot of people, but with more detail, that budget has to do with funding for your police department, and those park permits have to do with a New Year's Eve fireworks display where people have young children and animals at home. It's probably going to draw in a lot more people than our agenda on the left. Again, agenda on the left is not necessarily a violation, but if you just use more detail, you go into more detail, you cut down on ambiguity, you cut down on questions being asked, it's much more clear for members of the public. So something I do want to point out, we had a Sunshine Law complaint last year filed against an entity again in the southern part of the state that I'm not going to name, where you'll even notice on our left side we have unfinished business and we have two subtopics, budgets and park permits. But this entity was using unfinished business with no subtopics to discuss anything that had ever been discussed in a previous meeting, regardless of how long ago it was. And in this particular incident, the complaint was filed. We ended up looking into it, and the entity was discussing funding for its police department in August of 2023. They didn't make any decisions, they didn't do anything else on it, but then in September of 2024, more than a year later, they put on their agenda unfinished business. No subtopics or anything, and that's what they use to discuss their funding for their police department. So if you're a member of the public who cares about police funding in your community, how are you supposed to know that that is what that city or that county was supposed to be discussing? So in that particular situation, our office found that to be a likely violation of the Sunshine Law, and that entity actually agreed to go through Sunshine Law training as a condition of closing that complaint. And the good thing about doing that, rather than taking any type of legal action as far as a court, as you can imagine, it's very expensive to file lawsuits. And with the number of complaints that we get, it's just, we don't have the resources to file a lawsuit in every single case that we come across. So what we do is we use our trainings as kind of that first step. Because now we have this entity on the record as having gone through training. So if any issues pop up in the future, the excuse or the reasoning, well, we didn't know, can't really be used, because you've gone through Sunshine Law training, you should have known better. So that's how we kind of help get out the word on the Sunshine Law with our office.
So on that, I don't have anything to do with that
Yep.
part, but on that specific part of the unfinished business, and they just put unfinished business, have they come through and they said unfinished business police budget, is that enough information, or does it need to be police budget from August 11 months ago? I mean, give us an example of what you're looking for.
So, again, since there haven't been any clarification, and it says reasonably calculated, so if that's on their agenda under unfinished business and police funding, I mean, could that be enough information for somebody who cares about police funding, rather than just saying, well, we're gonna go back and discuss what we discussed a year ago?
Right.
So generally speaking, that would be sufficient if that was on their agenda, if they mentioned police funding and that's what they intended to discuss. So recording meetings. The public body shall allow members of the public to record all open public meetings, both audio and video. A public body is allowed to establish guidelines regarding the recording process. I mean, we don't want a situation where somebody's shoving a cell phone or a camera in board members or commissioners' faces. So a board can establish reasonable guidelines regarding the recording process, but they can't prohibit members of the public from recording an open public meeting. There's also no requirement that the member of the public notify the board that they're going to be recording that meeting. They don't have to show them your cameras to be able to show that you're recording. There's also a question I got recently, well, what if we record our meetings live on YouTube so people can either watch it live or they can go back and watch it later? As a matter of transparency, as a matter of public service, our office absolutely recommends that you do that. But even in those situations, you still can't prohibit members of the public from making their own recorded copy of that meeting. The right to record a meeting does not extend into a closed meeting. So nobody can record a closed meeting without the permission of the public body. That includes sitting members of that board who are meeting in that closed session. The statute doesn't make any differentiation between people sitting in that closed meeting as members of that board or their invited guests. So I know a lot of boards and a lot of public bodies like to record their closed meetings for posterity or for their minutes. So if you're going to record a closed meeting, best practice would be to take a vote on the record to specify who's going to be recording and by what method they're going to be recording. That way it's encapsulated in your minutes and there's no question later on that that recording was authorized. If you do record a closed meeting without permission, it's actually one of the few things in the Sunshine Law that is actually a criminal offense. So it's a crime to commit to record a closed meeting without the permission of the public body. Best practice for all public meeting notices is make sure to post your meeting notices and agendas in an area that is easily accessible to the public, even after business hours. And consider posting more than one physical notice. So regardless of what type of meeting you're having, if it's an in-person meeting, if it's a conference call, if it's an electronic meeting via Zoom or WebEx, a physical posting for that notice with that tentative agenda is always required. And it's only one physical notice. A body can absolutely post more than one physical notice, which we recommend as a best practice, but only one physical notice is required at the principal place of business. So if it's a city council meeting, city council headquarters. If it's a county commission meeting of the county commission headquarters. Again, you can certainly post more, but only one physical posting is required. And it says here that it must be accessible to the public even after business hours. So say, for example, the meeting was being held here, and the body posted the notice of that meeting on this wall, or if this building was locked after business hours, there's no way for people to be able to view that. So that would likely not be in compliance with the statute. So you'd want to post it on an exterior door where members of the public have the opportunity to view that after hours when the doors are locked, if they're walking or driving by. If your meeting is being held online, oh, yes, sir.
What if the mayor is not available and there's other board members still in place? Are they allowed to assemble?
So the Sunshine Law doesn't talk about who has to constitute a quorum, but if the mayor is a sitting member of that board and he's considered a member of that board, when the board decides how many people constitute a quorum, if that quorum is present, then that's considered a public meeting. But there's nothing in the Sunshine Law that says the mayor is or is not part of the quorum. That's up to the public body to decide whether or not he constitutes part of that quorum.
I'm in that situation where I was installed to be the mayor because our sitting mayor refused to
Okay.
quit.
So it might be a good idea if the city council or whatever board you're sitting on establish a policy that states whether or not, because Sunshine Law doesn't even talk about how many people constitute a quorum. Generally speaking, just from the definition in the encyclopedia, it's a majority of that sitting board, but it doesn't say whether the ex officio members or the mayor or the deputy mayor are considered part of that. So it might be a good idea to have some sort of policy that defines that, what constitutes that quorum, so it's much more clear, not just to you, but to the public as well. So if your meeting is being held online, so it's Zoom, it's WebEx, Microsoft Teams, you not only have that physical posting requirement, you also have to post online as well. The statute actually specifically says your website. A lot of smaller jurisdictions don't have websites, they have a Facebook page, or they have an Instagram. That's generally sufficient if you don't have a Facebook page. So if you're having that online meeting, you have to post physically and on your website, but alternatively, like I said, Facebook or Instagram. Those two posting requirements if it's an online meeting. Include the date and time the notice and the agenda was posted. So in the bottom left-hand corner or right-hand corner, if you post the date and time, just jot that down. And that's helpful because a lot of times, for example, at our office, we'll print off documents today, but won't actually put them in the mail until tomorrow. So it's helpful to actually write a physical notation that actually went in the mail on the exact date. And that covers you, so you're not having to remember 6 months or a year down the road, hey, did I post that notice? Who posted it? What time did they post it? What date did they post it? It's kind of encapsulated, so if you happen to get if a body is being accused of not posting notices of that meeting, if you have a physical notation, a lot of times it's a lot better than the actual printed notation on that. Include the name and contact information of your custodian of records. So a body on its notice or its tentative agenda, put the contact information for your custodian. And that cuts down on the chances of people calling your public body saying, hey, I'm trying to get in touch with the custodian, but calling multiple people. It's a lot more transparent, it's a lot clearer if you just put that information on your notice or your tentative agenda. And by the way, when it comes to the notice or the tentative agenda, those two documents can be one. Your notice and your tentative agenda can be one document, or they can be two separate documents, but if they are two separate documents, they do need to be posted together. And just be as specific as possible in drafting your tentative agenda items. We do get a lot of complaints on tentative agendas, and because the statute is not super clear and there haven't been any of those court cases that have further defined it, it's just helpful if you as a body, if public bodies are just as detailed as they possibly can. There's actually a lawsuit that's pending in the Western District Court of Appeals down in the Kansas City area. It's against a fire protection district where a member of the public filed a lawsuit against this fire protection district saying that their tentative agendas were not reasonably calculated. And their rationale for that is that over a multiple year period, at every single meeting of this public body, they were amending their agenda to add an item to that agenda. And it wasn't just happening once or twice, it was happening over a 2-year period. So if that public body is modifying its agenda and adding items at every single meeting in less than 24 hours, were those agendas truly reasonably calculated to advise members of the public of the matters to be considered? Our office is actually not a party to that lawsuit, but we actually did write an amicus brief encouraging the court to provide more clarification on tentative agendas and how much detail has to be in them because we do get so many complaints on tentative agendas. So minutes. So if a body has a meeting, either open or closed, you are required to take minutes of that meeting. Those minutes must include the date of the meeting, the time of the meeting, the place or location of that meeting, members present and members absent. So you have to actually list the members there and the members absent by name. It can't just be 5 present, 4 absent. You actually have to list John Miller present, Tammy Miller absent. And that's for members present and absent only refers to members of the board. Like for example, if this was a public meeting, we wouldn't need to take attendance on every single person in this room. It would just be the members sitting on the board that need to be in those minutes. A record of all votes taken. Every vote taken in every meeting, either open or closed, must be recorded. Roll call votes must specify each individual member's vote. So if a roll call vote is where a member of the public can discern who voted what way. So again, Tammy Miller voted yes, John Miller voted no. Or you can list all the yes votes and everybody who voted yes, and all the no votes and everybody who voted no. Either one of those is acceptable. A vote taken in a closed meeting must be a roll call vote. So they must have the vote attributed with a person's name in a closed meeting. Our office also recommends you do roll call votes for open meetings, but doing a roll call vote for open meetings is not required. It's only required for closed meetings. But just as a matter of transparency and openness, we recommend you do a roll call vote for open meetings as well. If your meeting minutes are in a closed meeting, you have to state the specific subsection of 610.2.1 that authorizes you to close that meeting. There are those 26 reasons under 610.2.1. There might be multiple reasons why you're closing that meeting. So this meeting is closed pursuant to 610.2.1 subsection 1, legal. Subsection 3, hiring and firing. Subsection 13, personnel. It's not sufficient for a body just to say this meeting's closed pursuant to 610.2.1. and not state a subsection. The body needs to state a subsection as to why that meeting is closed. And if applicable, the good cause to hold that meeting in less than 24 hours, or if you're modifying your tentative agenda, the justification, if you're holding that meeting in a place that's not reasonably accessible to the public, etc., you do have to state that justification in your minutes. And again, just with our notice and our tentative agendas, just be as detailed as possible with your minutes. It's a lot clearer, it's a lot more transparent, and it's easier for everybody. Closed meetings. Closed meetings are usually permissive, they are rarely mandatory. There are some situations when a body must close a meeting. A lot of times that has to do with getting advice from your legal counsel. But for the most part, bodies are authorized, not necessarily required, to close meetings, records, etc. But if you do, it has to be kind of one of those 26 reasons. This says 25 separate reasons, it's actually 26. Last year, 2023, there was actually one subsection added to 610.021. I believe that had to do with closing complaints that had to deal with government waste and fraud to the state auditor's office. So again, if you do have a closed meeting, you do need to state one or more of these 26 separate reasons for closing that meeting under 610.021. Remember that it is not just a best practice, it is a requirement that all business must remain open unless it is authorized to be closed. Remember, everything is open by default. They have to have that. Public body has to have a legal reason to close meetings, records, etc., and they have to provide that legal reason to you. Liability most often happens for improper closure, not for over-disclosure. Chances are a body's going to get in more trouble for closing something that it shouldn't, as opposed to opening something that it's not really sure about. And when it comes to that liability, the Sunshine Law covers what information can be closed. If a body chooses to open records, and that opening of those records or those meetings was not appropriate, those are other laws that cover that. The Sunshine Law doesn't cover when a body decides to open a meeting and it's not appropriate. It's only when they decide to close a meeting and it's not appropriate. We do get complaints from time to time from somebody saying, this public body provided my email address and my home address. Because everything's presumed to be open, you need a legal reason to close it. And a lot of times, if you're sending correspondence to a city council or a county commission, unless they have a legal reason to redact your email address or redact your phone number or your home address, generally speaking, they can't redact that information or withhold that without a reason. So I mentioned a little bit about 26 reasons under 610.021 where a body can close meetings, records, etc. These are some of the most common exceptions for closing meetings, records, etc. And you'll notice that some of these have an asterisk next to them. We refer to these as an evidence-based cutoff. So while the body may be able to close meetings, records, etc. for a certain amount of time while a particular matter is pending, at some point the records associated with those matters are going to become an open record. And one of the examples I give is subsection 11 and 12, the bid process and sealed bids. So a body, say it wants to close the intake of bids because they want to build a new police department or a new health department. They can take those bids in closed session. Once those bids have been unsealed, the winning bidder has been selected, land's been purchased, construction's been complete, all the legal requirements for that particular endeavor are now done and over with. Chances are the records associated with that endeavor is going to become an open record. And when that happens is going to be a decision for your legal counsel. Hey, somebody's made a request for records associated with endeavor XYZ. Everything's done on it. Are these records now open, or can we continue to close these? And if so, why can we continue to close these? That's actually a question that our office gets quite a bit. Like, hey, this body is not opening these records. We can't. They're saying that it's closed pursuant to X, Y, and Z. Again, that's not a legal determination that our office can make. That needs to come from the attorney for that public body. Personnel records. We can cover a little bit about the personnel records, that a body can close the personnel records of its employees except for the name, title, salary, and length of service. Subsection 3, hiring, firing, discipline, or promoting. So this refers when a body is taking actions against specific employees. A body, for example, couldn't use this subsection to say they were looking at salary increases for everybody across the board. They couldn't go into closed session pursuant to this subsection to discuss salary increases for everybody. It's if they're hiring a new public works person, they're firing their clerk. An interesting thing about the Sunshine Law, I want to make sure I cover it here because I don't want to forget to do it, is that in a closed meeting, that if there's a vote taken in a closed meeting, The vote is a public record. So if, say for example, the board decided they were in a closed meeting for real estate, and the board took a vote on something in closed session, the vote of how each member of that board voted, John Miller yes, Tammy Miller no, would be opened, even if the discussion about what they were talking about can continue to be closed. The only exception to that would be under subsection 3, the hiring, firing, discipline, or promoting. So if a body takes action, they take a vote in a closed meeting and they're meeting under subsection 3, they're firing that clerk, they're hiring a new public works person, and somebody makes a request for the results of that vote, the body can withhold the results of that vote for up to 72 hours. But in that 72 hours, they would need to make the person who the vote was about aware. So say they fired the clerk in that meeting, and then somebody makes a request for the results of that vote. They could withhold the results of that vote for 72 hours, but they must inform the clerk, hey, a request has been made for results of the vote. We're just letting you know before we release the results of the vote, because they have a right to know before that vote is released to the public. This does not require the public body to publish the results of the vote, but it's only if those requests for those votes is made upon request. There's also a misconception that when a body takes minutes, that the body is required to post the minutes. The Sunshine Law does not require a body to post the minutes of its meetings. If you make a request for the meetings, the body has to provide them or state why they're closed, but they don't have to post those meeting minutes. We recommend as best practice a body does, just for transparency and openness, but there's no requirement that they post the minutes after a meeting, only that they make them available upon request.
Are draft minutes sunshineable?
What's that?
Draft minutes.
So there is nothing in the Sunshine Law that requires a record to be in final form. There was actually a court case. It's Allen versus the Missouri Advocacy Services. I know Allen was the person that filed the lawsuit, and it was against the Missouri Department of Education. So if requests are made for draft minutes, then yes, those draft minutes are prepared, they just haven't been finalized, then generally speaking, yes, those are considered a public record. So a body would have to provide those pursuant to a records request unless they were otherwise closed. And in those cases, we recommend that if a body, if they're going to release those draft minutes, to put a watermark or something along on the document that basically says it's a draft, this is not the final version. That way there's no confusion when there is a final version later on down the road. Subsection 14, prohibited from disclosure by law. I call this one the catch-all, because while we have these 26 reasons under 610.021 that can close meetings, records, etc., there may be other laws outside the Sunshine Law that authorize or require records to be closed. And examples of that would be HIPAA. HIPAA protects the confidentiality of medical records. Missouri has laws on the books that protect the confidentiality of juvenile records in law enforcement records. I think that's 311.321. There are laws on the books that protect the confidentiality of sexual assault victims. All those three examples are laws that exist outside the Sunshine Law. So if a body is going to use a law outside the Sunshine Law that authorize or allow it to close certain meetings and records, they not only have to cite subsection 14, prohibited from disclosure by law, but they have to tell you what law that it is. We've had complaints against public bodies where the body says, well, these records are closed because subsection 14 says they're prohibited from disclosure by law, and they don't state the law. The body has to tell you what law authorizes it to close those records. Anything else on here? How to close a meeting. So the statute talks about two different methods for closing a public meeting. A public governmental body may vote by an affirmative public vote of a majority of its quorum to close a meeting. So this one's talking about a body is in its open meeting and they're going into their closed meeting. The body is required to take an open public vote, roll call, to go from its open meeting into its closed meeting. One question I got recently was, well, does that happen with one vote, or do we have to take two votes? Do we have to take a vote to leave our open meeting and a second vote to go into our closed meeting, or can one vote accomplish both? That's up to you as a body. There's no requirement that there be two separate votes, but a lot of times as a matter of transparency, a body will say, well, we're going to take two votes, one to leave our open meeting and one to go into our closed meeting. Sunshine Law doesn't say anything about that. It just says there has to be at least one vote. So you can accomplish leaving your open meeting and going into your closed meeting with one on the record roll call. Second one, a public governmental body may give notice of its intention to hold a closed meeting and cite the exception of 610.021. So this one is talking about a public governmental body is not gonna have an open meeting beforehand, they just decided to hold a closed meeting. They are still required to post notice of that closed meeting 24 hours in advance in a public place that's reasonably accessible to the public. They have to post the tentative agenda, and they have to tell you what section of 610.021 authorizes them to go into that closed meeting. Only close a portion of the facility used for closing the meeting and only discuss business necessary that justifies that meeting's closure. I put this bullet point in here, or this disclaimer in here. As I was investigating a complaint last year, I came across a body that had voted to go into closed session. And sometimes, when people do, you get into your meeting, hey, what'd you guys get up to this weekend? What'd you do? There was about 35 or 40 minutes of personal discussions that had no correlation or connection to why they went into that closed meeting. And these discussions eventually turned to discussions about their constituents. They were talking about people who voted for them, the things that they probably shouldn't be saying in a meeting. Well, fast forward down the road, they get into their meeting, they have their meeting, and a lawsuit was filed by a member of the public to gain access to this meeting. The person had no idea about the personal discussions of this meeting. They wanted access to why that meeting was closed. The court looked at that particular gathering and said, well, they posted notice 24 hours in advance, they posted the tentative agenda, the reason for going into closed session was valid based on what they discussed. That meeting is going to remain closed. However, this 35 or 40 minutes of personal discussions had nothing to do with the reason for them going into that closed meeting. So the court opened up that portion of the meeting. And for whatever reason, this particular body had voted to record its closed meeting. So now you have these elected officials talking about their constituents on this audio recording, and as you can imagine, that did not go over very well for some members of that elected body. So when a body goes into its closed meeting, don't deviate from topic, stick to exactly why you're there and why you're in closed session. Okay, any public meeting questions? And by the way, I'll leave questions open for questions after, so if you have a question that you can't think of now, you want to ask at the end. And I'll stick around for a little bit, because I know a lot of people don't like asking questions in a group setting. So I'll stick around, Brandon and I will be able to answer questions on a more smaller basis, so people don't have to ask your questions. Do we have any public meeting questions before we move on to the public records portion?
We had a request for, a guy called us, or requested it on paper, that he wanted a copy of our minutes for the year. Is that something we need to follow throughout, year after year, or does he need to request that every year?
So,
Or every month?
generally speaking, a body has to retain records in order for them to be made available. If the records don't exist, you can't really make a request for records that exist. Like, I want copies of your records for next month's meeting minutes. Well, you haven't taken those minutes, so you don't retain those records. So generally speaking, if you have the time and the effort and you want to do that as a matter of public service and do that for that member of the public, that's up to you, but there's no requirement that a body honor something for records that are made in perpetuity. Okay. Public records. So what is a public record? The Sunshine Law defines a public record as any record, whether written or electronically stored, that is retained by or of a public governmental body. And the courts have construed records very broadly. They can be written records on paper, they can be electronic records and emails, they can be items held on a thumb or a flash drive, and they can be older forms of records. VHS tapes, cassette tapes, those little tiny cassette tapes they used to use way back in the day. I know in our public safety section, we have a lot of old homicide cases where a lot of the depositions, a lot of the interviews were all done on VHS tapes. So if somebody were to make a request for those records, our office would need to reproduce those in order to provide them pursuant to a record. So what records must be retained? We get a lot of questions about, do I have to keep this record? And if so, how long do I have to keep this record? That's not a that's not a Sunshine Law question. That's records retention is covered under Chapter 109. So if a body has questions about, do I have to keep this record, and if so, for how long, our office doesn't have any authority over Chapter 109. That's the Secretary of State's office. So if you have a records retention question about how long you have to keep a record, or if you have to keep it at all, you're going to want to reach out to the Secretary of State's office. If your question is this meeting open or closed, or these records open or closed, that's a Sunshine Law question, and that falls under 610 of the Sunshine Law. Electronic transmission of public records. So always remember that as a general rule of public records, any record, whether written or electronically stored, by, of any public governmental body is considered a public record. So say, for example, I send an email to Brandon from my AGO email to his AGO email, and I say, hey, I'm running out to Subway to go grab a sandwich. Do you want anything? It has nothing to do with public business, but because I sent that from my government email to his government email, and that email is retained as part of our records retention policy, if someone were to make a request for that email, we would either have to provide it pursuant to a records request or state why it was closed. Also remember that under 610.025, that an electronic record may be considered a public record if it is sent to a quorum of officials, which includes the sender, and it relates to public business. So if you're sending emails back and forth to your quorum of your board or a quorum of your public body, and that includes your sender, you are required to keep that email or that electronic communication. The length of time you have to keep it is a question for the Secretary of State, but there is a length of time about how long you will have to keep that email. If the message meets the above requirements, the best practice is to send to the member's government-issued email device or to the custodian of records. So if you happen to receive an email about public business on your personal phone or your personal device, the best practice is to forward it to your government email address. Is there anybody in here who works for a public body who is still using a Gmail or a Hotmail or an Outlook.com to conduct public business? So not using a .gov or an official city or public governmental body email address. Okay, I don't see any hands, but if you are, it's a good practice to have an email address that is separate from your personal. You don't want to get into a situation where you have your personal email address and you're using that to conduct any type of public business. The reason for that is, number one, there haven't been any court cases that have said that because there's public documents on my personal phone, and now my personal phone becomes discoverable or can be reviewed pursuant to a records request. But because it's still happening so frequently in Missouri, people are still using a Gmail or a Hotmail or an Outlook, you don't want to get into a situation where your personal emails are now open just because you have public records on there. You don't want to get into that kind of situation. So best practice is if you are using a Gmail or a Hotmail or a private email address to conduct public business, if you do happen to get any type of public business, either send it to your government email address or an email address that's for your custodian or one that's dedicated specifically to your public business. It's not related to your personal at all. I know a question is probably going to come up. It comes up in every training that we do. What about cell phones? So if your cell phone is issued by the public body, so the city, the police department, generally speaking, that cell phone is generally considered to be a public record. If it's a personal cell phone, even if that personal cell phone is paid by the public body, there haven't been any court cases that have said that that is a public record, which is why you want to keep it separate. If you're using a phone, even that you're giving a stipend from the public body, you want to keep your correspondence and your government correspondence separate from your personal correspondence. You get a lot of questions on that. So again, if the message meets the above requirements, the best practice is to send to your government-issued device or to your custodian of records. Best practice is for each public governmental body to have a government-issued email account, but we know that's not always practical, especially in a lot of smaller jurisdictions that are still using that Gmail or Hotmail. So you kind of have to do the best that you can. So keep that government business and your personal business separate, two separate email accounts, one dedicated to your government business and the rest for your personal.
So sorry, just to take off that. So I'm functioning in here and I'm on the school board or on a health department board or I'm on a library board, whatever it is, and they're sending me a text to remind me about the meeting today or tomorrow, whenever it is. Do those have to be retained? Or-
So
Okay.
if it's something just like, hey, don't forget this meeting kind of thing, generally one or two text messages along those lines generally wouldn't really constitute any type of public business. But if it's like, hey, what are we going to talk about at the meeting? Oh, we're going to discuss this and this and this. Hey, how are you going to vote on this issue? If it's just a reminder or something, it's generally doesn't really fall into that umbrella. If, as a best practice, if you want to just make sure you're covered, you can take a screenshot or then forward that to your government issued email address so that you're covered. But if it's just a reminder, hey, don't forget the meeting tomorrow, that generally doesn't fall into that.
But along that line, if I'm on the library board or whatever board I'm on, and I'm a private individual and I don't have a government email, and I'm using my email account for that,
So best practice in that case would be to forward any type of that correspondence that have to do with your official role on that board to your custodian. That way your public body has it and it's not on your personal device anymore.
yeah, I'll also, and maybe you're gonna talk about this in a minute, but when you're talking about Zoom meetings or team meetings or whatever it is, in this day of AI note-taking or recording that way, is that stuff that has to be kept in perpetuity, or is it something that after you've got your official minutes, you can?
So again, what you have to keep is, it will be up to the Secretary of State. I've seen situations where a body has recorded a meeting or through AI or whatever, and then they transcribe that into minutes, and they've kept the minutes and they've gotten rid of the audio, or they've kept both.
Which is what makes sense to me.
Yeah, but if that is required or not is a question for the Secretary of State. And the last time that we spoke with them on that issue, as long as you're keeping a record, I don't know that there's a requirement that you keep both.
Okay.
But I'm not saying that definitively, but the last time we spoke, because it does come up quite a bit with our office. In fact, I think the end of 2023 is the last time we spoke to the Secretary of State. And as long as there is a record being kept of that meeting, your written records, that there's no necessarily a requirement to keep your audio. And that's another thing that comes to records retention. The Secretary of State's office has their records retention on their website. They have one for the city clerk, they have one for the health department, they have one for the county commission. They have it broken down, and they're all available about how long you have to keep certain records. You have to keep records according to what the records retention policy says, but that doesn't preclude you from keeping records longer than they say. You just can't keep those records for shorter than what the records retention requires. So submitting an open records request. So a sunshine law request can be submitted a variety of ways. You can submit it by letter, you can do it by email, you can do it by phone call, or you can do it in person. The sunshine law actually does not require a specific submission method. So while a body can request that you use their form, they cannot require you to use their form. However, I will tell you that as a best practice, it's always best to do it in writing. Because we have had multiple situations where somebody said, well, I didn't want to put it in writing, but I made a phone call to the public body, I gave my request over the phone, and 3 weeks have gone by, nobody's gotten back to me. So I will call they'll call in a complaint, I'll call the public body, and that clerk will tell me, I have no idea who that person is, I've never talked to him in my life. It becomes a he said, she said kind of situation. There's no way to verify that request actually came in. So it benefits you as the requester to do that in writing, because now you have a paper trail, that body has 3 days to respond to you. Everything's better with a paper trail. So even though you're not required to put it in writing, it's beneficial not just for the body, but for you as the requester to put that request in writing. Public governmental body must act on the request as soon as possible, but no later than 3 business days after the custodian receives it. So say you are the custodian for your public body, and somebody puts in the request at 4 p.m. on Friday, and you went home at 3 p.m. on Friday. And you don't come until Monday morning, you open up you go in, you get your coffee, you get a donut from the break room, and you open your email at about 10 o'clock on Monday morning. When does that first day of that 3 business days start? Monday. Anybody have any ideas? Throw some out. Monday. Somebody said Monday? It's actually close of business on Tuesday. The statute says that you have to respond to the request on the 3rd day following receipt. So if you received it on Monday, the 3rd day following receipt would be Tuesday, Wednesday, Thursday. So close of business on Thursday is when you would need to have that response to that individual. So that first day, close of business, would be that Tuesday. So bodies should not use this as a way to circumvent or getting around the sunshine law, but that does give a little bit of leeway as far as when and how to respond. And that comes out of this court case here decided in 2021, Starr versus the Jackson County Prosecuting Attorney. And in this particular case, somebody had actually made a public records request to the Jackson County Prosecutor. And the prosecutor was actually providing the records, they were gathering them up, giving the person their records, but at some point something fell through the cracks and the person did not get their records. So the person ended up filing a lawsuit. And when the court looked at that particular records request, they noted that the custodian of records for the Jackson County prosecutor was the prosecutor herself. And she never even saw the records request until the lawsuit was filed. So the court held that that records request was not properly received by the custodian of records. So you have to send your request to the custodian by name or by title. You have to phrase your request with specificity using language that a reasonably competent custodian of records would understand. A body has to understand what it is that you're requesting in order for them to provide records. So be as detailed as possible with what you're requesting. We recommend that if a body happens to get a request, give me all your emails. It's very vague, there's no dates, there's no topics, there's no names and titles of employees. For a public body to do its due diligence and reach out to the requester and try and clarify that. Hey, you said give me all your emails, but you didn't give any date ranges, you didn't give any topics, you didn't give any names, titles of employees. Can you provide that information so we can figure out what we're going to, how we can provide that information to you?
So if you respond within that 3 days, you don't really have to give them the request, you just have to respond, touch base with them, or do you got 3 days to satisfy that request?
So you have 3 days to provide a response. If you can provide the records within those 3 days, you should provide those records to them. But if you can't, you need to explain why, and you have to give them a hard, fast date and time of when they can expect those records. And we'll talk about that in our next slide, actually. Responding to an open records request. A public governmental body must act on the request as soon as possible, no later than 3 business days after the custodian receives it. So within that 3 business days, you have to respond to the requester and say either, here's your records, but if you're not providing those records, you have to tell them why, you have to give them an explanation, and you have to give them a hard, fast date and time. There was a lawsuit that was decided against the governor's office a few years back, where the governor's office's practice was, well, you can have your records on Thursday, or a week from Friday. And the court said that was not an acceptable response. You need to give them a hard, fast date and time. Your records will be ready on December 31st at 4 p.m. You can always extend that date out if there's a reasonable cause for delay, but you do have to give them a hard, fast date and time. Give that explanation as why the records are going to be delayed, provide the earliest date and time. Try to address those fee estimates, what you're going to charge in that initial response letter, in that 3-day letter. That way the person knows approximately what they're going to be paying for those records. Try to do your initial search, so that way the person knows approximately how many records are going to be responsive as well. All employees should know the identity of your custodian of records, and all employees should forward the records request to the custodian. So say you're not the custodian, and you happen to receive a records request. Best practices is to forward that records request to your custodian and include the requester on that email. So all 3 of you are on the same page. The custodian now knows they have a records request they need to get to work on. The requester now knows who they need to reach out to, and it's off your plate, not being the custodian, and you don't have to worry about it anymore. Records can be held in more than one location, so we recommend that you do that diligent search within that 3 days. Like, for example, our office, we have a ton of physical records, but now we've been trying to go digital, so we have a lot of electronic records as well. So we try and do that, figure out how many records responsive to each type of record. Contact the requester in writing, just how we recommend the requester put things in writing. It's also beneficial for the request or for the public body to put things in writing. Confirm the body's understanding of what is being requested and engage with the requester to clarify any possible fees. Confirm the way the records will be produced, if they want them physically, if they want them electronically. Kind of establish that on the initial contact with them. Be very specific, explaining why those records can't be provided within those 3 business days. You have to provide as much detail as possible, and remember to give them that exact date and time that they can expect the records. If there are no records responsive to a request, the public body still needs to let the requester know. We've come across situations where a body has said, well, we didn't have what they were requesting, so we didn't even respond. That's not something that a public body can do. You do need to respond to the requester and let them know that there are no records responsive to the request. Redact whatever possible instead of withholding an entire record. There's actually a section of the Sunshine Law, it's 610.024. So say, for example, there's just one document that has a social security number that's on it, that is redacted. But everything else on that document is open. The body shouldn't withhold that entire record, but instead should redact that social security number and provide the rest of the record to the requester. 610.024 actually states that if there is a record that contains exempt and non-exempt information, that the body can withhold their exempt information, but they do need to provide the non-exempt information. Obvious reasons for closure, such as work product, are encouraged to be stated on the document. So if it's work product or other type of closed record, try and specify that on the outset. That way your custodian is not having to flip through multiple pages of a document to determine if something is open or something is closed. Another area we get quite a few complaints on, Sunshine Law does not require a public body to create a new record upon request, but only to provide access to existing records that are held or maintained by the body. So I'll give you an example. Say a city council or county commission decides to hold a Christmas party here in the community center. And public is coming, members of the public bodies are coming and going. A couple days later, somebody makes a request for the sign-in sheet. Well, say for example, we didn't keep a sign-in sheet. A public body doesn't have to go back and create a record in order to provide it to you. However, if the body kept a sign-in sheet, it would be considered a public record, and they would either have to provide it or state otherwise why it was closed. But if they don't have a record, they don't have to go back and recreate it in order to provide it. Same provisions of 610.021 apply to your closed records that apply to your closed meetings. If records responsive to a request are closed, provide a response that generally describes the material being exempted, unless that description will reveal the contents of the exempt information. So here a body is trying to tread a very thin line about what is closed without revealing the exact contents. Redacting whenever possible instead of withholding an entire record. Again, a body is not permitted to withhold an entire record if there are information in there that just has a few things that are closed. They do need to withhold the closed information, and then they can provide the rest of the information to the requester. Best practice when closing records, provide information to the requester or what documents have been closed in the final response letter. So if a public body is going to close records, or they're going to redact records, they can't just state these records are closed pursuant to 610.021. They have to state the specific law, that subsection of 610.021 or some other law. These records are closed pursuant to HIPAA or their juvenile records. Because if a body does that, if they send you a closing letter saying, well, these records are closed pursuant to 610.021, the requester can then go back to the public body and say, well, you didn't give me a subsection. 610.023.4 requires that you give me that information. So now the public body has given itself another 3-day window to provide that information to the requester. So if they just state the specific law that authorizes those records to be closed in their final response letter, the body saves itself from another 3-day response time to provide that information. Okay, some final thoughts. Remember that when in doubt, a meeting or record of a public body should be open to the public. So if the scales are kind of even about whether to have a closed meeting or an open meeting, the scale tips towards the side of openness. It's always better to open a meeting rather than close it. Sunshine Law applies to all records, regardless of what form those records are kept in all meetings, regardless in the manner in which those meetings are held. The Sunshine Law allows a public body to close meetings and records in some limited circumstances, but it rarely requires a public body to close meetings and records. Except in emergency situations, a public body must give at least 24 hours public notice before holding a public meeting. If the meeting will be closed to the public, they must state in the notice a specific provision under 610.021 that authorizes that meeting to be closed, one of those 26 reasons. Each public body must have a written Sunshine Law policy and a custodian of records named by law. And that policy and that custodian's name is open to the public upon request. The Sunshine Law requires a custodian of records to respond to a records request as soon as possible, but no later than 3 business days after the custodian receives it. Remember, just because the request was sent doesn't mean it was received by the custodian. When responding to a request for copies of its records, the Sunshine Law limits how much a public body can charge per page and per hour for copying and research fees. Those fees are contained in 610.026. There are specific provisions governing access to law enforcement and judicial records. So those judicial records of that Missouri Supreme Court Rule 2. Law enforcement records are specifically covered under 610.100, and it depends on whether there's an active investigation, whether it's inactive, whether charges have been filed. If law enforcement agencies are interested in our specific law enforcement training, let me know after the presentation. We do have that as well. The Sunshine Law allows open public meetings to be with audio and video recorded by attendees. Each public body may set up guidelines regarding the recording process. These guidelines should be included in the body's Sunshine Law policy. Remember that no one is allowed to record a closed meeting without the permission of the public body. So if you're going to record those closed meetings, make sure you take that vote on the record to specify who's going to be recording and by what method they're going to be. The Sunshine Law deals with whether a public body's records must be open to the public, but it generally does not state what records the body must keep or for how long. That is a records retention question that you're going to want to reach out to the Secretary of State's office. I won't go through every single one of these, but basically our office is not the only office that's responsible for Sunshine Law compliance and enforcement. The state auditor is as well. And when they go out and do audits of public bodies, one of the things that they do is they do a Sunshine Law audit. And these are some of the most common potential violations that they came across while doing their audits. And we tried to incorporate all of these into our presentation to try and cut down on the potential for future violations within public governmental bodies. And that concludes our presentation. Do we have any questions? And I will stay after if somebody doesn't want to ask their question in front of the crowd, but I'm willing to take questions if anybody has any.
I have a question.
Yes, ma'am.
I was just thinking of someone who is your public governmental body, okay?
Okay.
And she had received a sunshine law request, and I was surprised because, again, this is not always my world. I was under the assumption that it applied mostly to the minutes and the meetings, and she was telling me that it was from an out-of-state business that asked for financial reportings dealing with purchases, and that's not something that we frequently hear about, that you have to disclose. Can you talk a little bit about it?
So, we've been getting this question a lot recently about companies making sunshine law requests. The sunshine law does not require people to identify themselves. It doesn't require them to give a reason why they're making a sunshine law request. If you receive a public records request, you have to treat it as a public records request. But you can still charge those fees under 610.026 for the 10 cents per page. So yes, if companies are making these requests, and I think there's been so much grumble, I think that hopefully maybe the legislature or the General Assembly will take this up, that when these companies are asking for these large-scale productions, but you would treat that request no differently than you treat a large-scale production from a member of the public. They still have to be given a explanation of why it's going to be delayed, how much the fees are going to cost, when they can expect their records. Because a lot of times your custodian is not just doing public records requests, they're doing other duties too. So you have to factor that into everything else that they're doing. But you do have to treat that request as you would any other public records request.
In fact, they're bad in my interest that they didn't sell you something.
Yeah. Yeah, the sunshine law doesn't make that differentiation. Again, that's part of my opinion of the sunshine law is that it's 51 years old. There's a lot of things that it has to keep up with. It hasn't kept up with the times. And hopefully there will be some modifications and some updates. Yes, sir.
What's the actual address? Because I don't have computerized training, so I'd like to know what the address is if I want to contact.
So this is our email address, and that you want to mean physically, like our written address? Okay, so that is P.O. Box 899.
Okay, P.O. Box 899.
Yep, and it's the Supreme Court building.
Okay, what else?
The Supreme Court building.
Missouri Supreme Court?
Yep. And it's Jefferson City.
I'm slow.
That's okay.
Sweden.
Nope, it's just that's the direct P.O. Box for mail. And it's Jefferson City, and it's
Jefferson City, Missouri.
is it 64
I think it's 65103.
65103 or 65101.
I don't have computerized education.
Okay. Any other questions that we want to ask in front of everybody? Nope. Okay, I will stay on after for a few more minutes. If anybody has a question in person, I'll get this over to you.
Thank you, Jay. Can you guys give him a round of applause, please, for doing all of If you don't know me, I will be surprised. I'm the thorn in some of your sides. If you've gotten a sunshine request, it's probably been from me. So if you ever have a question about sunshine-related issues that I can help with, always feel free to give me a call. I'm the editor of the Edina Sentinel. My name is Menges. I'm also serving as the president of the Missouri Sunshine Coalition again this year, which is a statewide organization. It's been around for about 16 years. Also, Mike Scott, the publisher of the NEMO Media Group, is here. And without his support and allowing us to have this for all of our communities in our 7 counties that we serve, along with the Missouri Attorney General's Office, the Missouri Sunshine Coalition. Thank you so much for attending. It is a very unexpected but welcome, huge turnout. Please fill out your surveys before you leave, and you can just leave them on the table as you go out the door. If anyone wants to take a cup of coffee, some muffins, back to your office, please, we have plenty of extra, and we would love to